Hi everyone, welcome. We're just going to give it a couple of minutes while we wait for others to join, and we'll get started. Can you just yeah. Okay, everyone. We will have people joining us as we go on, but I'm just mindful that we did have a 10:30 start, so we will get started. I'm just going to start with some ground rules and some housekeeping. So this webinar is live and it is being recorded. So it's important that we understand the confidentiality provisions of the Child Protection Act. If you're wanting to ask questions, your microphone and camera have been disabled, but the chat function is available, and I have Danny Hemsley, one of our case officers here, that will be assisting me with the chat function. So by all means, put questions to us through the chat function, but just be mindful because it is being recorded, and we have 158 people registered for this webinar, that any questions cannot have any identifying information in relation to children or young people or people that you're working with within the department. So we just need to be respectful of privacy and confidentiality. I also want to let everyone know that this is the first time we're running this particular training on complaints management. Usually when we develop training within QFKC, we present the training to a small group of people and get some feedback as to how we could improve it or what we're missing. But no, this time we've decided to go and do a live webinar in front of potentially over 100 people. So please bear with me because it is our first training on complaints management. It is certainly an area that we're really passionate here at QFKC, and we're really excited to be able to share some really amazing up-to-date information for you in relation to how the complaints unit currently is set up. And as Foster and Kinship Care agency workers that are linking in today, how you can support carers resolving issues at a local level, and for carers having the empowerment to know what steps to take when you're trying to resolve matters as well. So we're really keen to hear feedback as well in relation to this training and what we can do to improve it. I do need to let you know also that, like with any other training that QFKC undertakes, we make sure that our information is accurate. So we take the training module to the most appropriate department within child safety, and they ensure the accuracy of it. So, for example, when we did the QCAT training that some people may have joined into, that training was seen by court services before we presented it to you. Training that we did in respect to long-term guardianship and permanency was seen by adoptions and permanency teams within child safety. And this training that you're seeing today is actually being viewed by the manager of the complaints unit for accuracy. So what we're hoping to do in this training is provide some really practical, practice-based examples of how we can go about trying to resolve issues in a way that brings about early resolution and reduces levels of conflict and helps carers really feel empowered to bring matters forward. So in saying all of that, I've got three of my colleagues in the room as well. You can see, you may be able to see Lisa, but I've also got Danny and I have Margaret in the room as well. And I have other case officers that are joining in via Teams. So welcome to all the staff and welcome to everyone else that has taken the time to join in today. So we will get started. I firstly want to start by acknowledging the traditional owners of the land in which we all meet today. We've got participants from right across the state, so I want to acknowledge all the lands in which we are sitting today and acknowledge elders past, present and emerging. Okay, let's get started. Danny's going to be my person that's going to be in charge of technology. So I will be looking over to him at times. And can you move it to the next one, please? Okay, so the content that we're going to look at today is taking a look at the past. I think that's really important in this training because, and I've been really clear with the department and with complaints unit and with head office about this, is that if you had asked me 2 years ago about going through a complaints process within child safety and what that would be like, my honest answer to you would have been, it's probably not going to be a very nice process. There's time delays, there's often outcomes that are not even received. Sometimes your complaint may not have even been recorded as a complaint, even if you thought it was. And so it was quite a difficult process to navigate. And I feel what occurred in that space is that people that had experienced going through a complaint in the past would avoid the complaints process following an experience of already lodging a complaint because the complaint process hadn't been a positive one. And in fact, in some instances, carers would feel that the complaint process itself has become part of the problem, that's part of the complaint because they haven't been responded to, timeframes have been delayed and, you know, all sorts of issues there. So we're really going to, the reason we're going to look at the past is because I want people to understand that things have changed. We'll look at what it was and what led to that change and where we're sitting today. We're going to explain the complaints unit. It's not called central complaints anymore. It's called the complaints unit. And we're going to talk about where that sits and what you can expect. We're going to talk about the complaints management policy and procedure. As everyone knows, QFKC is a peak body. When we undertake advocacy and support for carers, we do that using policy, procedure, legislation and other documents to support our advocacy. So it's important in this instance that we do the same, that we actually use the policy and the procedure that are newly developed to drive our understanding and our support and advocacy in this space. And then we're going to look at supporting documents. So the importance of actually using documents that are already available to us, policy, procedure, legislation, statement of commitment, Human Rights Act, all those really incredibly important documents that we use to actually formulate our complaints and our concerns and our issues when we bring that to the department's attention. We're going to talk about the complaint pathways and we're going to give you a few top tips here that we've used at QFKC, which we know work because we've used them and we've had some really amazing, incredible, successful outcomes. So that's what we're going to do today. Letting everyone know before I move on that the slides for this training will be uploaded onto our website, hopefully by the end of the week. And also on our website will be uploaded the recorded version of the training that you're listening to today. There'll also be the ability for you to download a certificate and have that recognising your attendance at this training today. So let's take a look into the past. So in 2014, there was the first audit that was completed around the complaints management system, and that was a recommendation of the Carmody report. It included 22 recommendations. They were provided to the DG at the time, but that particular document was not made public. So then in 2016, the first Queensland Ombudsman investigation took place. Now, I'm not sure whether people are aware of the role of the Queensland Ombudsman, but they are a public body that can look at concerns and complaints in relation to government departments. And that would be the final external avenue of complaint that carers have once they've accessed their internal avenues of complaint. But we're going to talk about that more as we go on. But I just wanted to give some background in terms of who the Queensland Ombudsman were. So they were tasked with investigating the department's complaint process, what was working, what wasn't working. And they completed a report back in 2016, including 5 recommendations, and some of those recommendations very much focused on the need for the department to have greater accuracy in their complaints. So then in 2020, the Queensland Ombudsman continued its oversight, and this is probably the most important report that we're going to focus on when we're looking at the past, because this is the report that resulted in the significant changes that we actually see today. This report was made public, and I'll show you a link and I think we've got a QR code in the training that you can link. And I really recommend that you take a look at that particular report, because it's actually a really easy read. And what the Queensland Ombudsman has done throughout that report is they've used de-identified examples of matters that have come to their attention where complaints have been made and where the department may not have followed a process that actually was conducive to having that complaint looked at, investigated and reviewed appropriately. So that report resulted in 9 recommendations, and we're going to talk about what those 9 recommendations were and how the department have implemented those. So that's a picture of the report that I was just talking about. Like I said, I would really encourage you to get hold of that report and have a read. It's an easy read. It's not a overly complicated report to understand, I felt, and it gave me really good insight into how we got to where we are today. So all of the 9 recommendations were actually accepted by the government, and I'm going to talk to you about what those recommendations were. I've got lots of paperwork in front of me, so just bear with me as I refer to those as we go on. So the recommendations were that the Director General of the department, all complaints received at the Child Safety Service Centre manager level are managed according to the complaints management system by providing further training to Service Centre officers about the process for identifying and recording complaints, and making Service Centre officers responsible for entering complaints directly into the department's management base. So that was really about, that recommendation really centred on recording and training, that CSOs and departmental staff need to understand when a complaint should be treated as a complaint, because what the report, and if you have the chance to read it, what you'll identify is that what was occurring lots was that things or complaints or matters that that carers were raising, and or birth parents or any other person that was a client of the department or working alongside the department, they were actually being responded to as issues. So the department were referring to them as issues, and because they were being referred to as issues, they weren't actually being recorded in the complaints management system. And then what the report identified is that it was just going round and round in circles with no resolution, and then things would, become more and more complex as the original issue actually was not being addressed through a proper complaints process. So that recommendation is very much around training for departmental staff to recognise when an issue is a complaint, and ensuring accuracy of recording of complaints. And so that feeds into recommendation 2, which says that the Director General of the department ensure that all contacts that meet the definition of complaint in the department's policy are recorded and responded to as a complaint. Especially this should be done by amending the department's procedure to remove the term issue. So the department's procedure at the time even referred to the word issue, and that's why they were being responded to in that way, which was a really informal way. And as I said, it was just what the report identified as we were just going around in circles, and that providing training to officers regarding the amended procedure and assessing that as complaints in accordance with the policy. Other recommendations were around ensuring that the complaint policy and procedure that the department had in place was actually in accordance with the Australian and New Zealand standard, irrespective of the complexity of the complaint, and to review processes to comply with that standard. And then there is a number of points there around how that needs to occur. That it be amended to ensure that there was a clear process for the management of complaints about funded services. Specifically, the policy and procedure should provide for accountability through identification of a single point of contact, and that the DG of the department and the Office of the Public Guardian, which we may know as the OPG, finalise the current review of the Memorandum of Understanding. So that's the document between the DG and the OPG for when the OPG raises concerns with the department. They've obviously got reporting requirements and responsibilities in their role, and so there needed to be an up-to-date Memorandum of Understanding about how they manage complaints between the two. And then the recommendation 7 was ensuring that the department required decision makers in respect of complaints about practice decisions to consider whether a senior practitioner review be undertaken, and provide guidance on how a senior practice review be incorporated into recording of a complaint. Recommendation 9 was that the DG ensure complaints management policy procedure amended to provide that a complaint decision maker is clearly identified for each complaint. So who is this being allocated to? Who is the decision maker in respect to this complaint? So really identifying a really clear process, and ensuring that the final recommendation that sustainable, consistent complaints management governance occurs in accordance with those Australian and New Zealand standards again. So that's a bit technical, but what I really want to do now is I really want to break that down into, okay, these were recommendations from the Queensland Ombudsman, but then, and the department accepted those recommendations. So then what occurred from a practice point of view on the ground. So let's have a look at that. So we were really clear that in terms of a timeline, once we had the second report from the Ombudsman, that we needed to stop using the word issue, and that the concept of what you will hear a lot today about the FAR process was introduced. Now, FAR means first attempt at resolution. So that's what that means, and we're going to talk about it a lot today. So then what occurred then? So we had the recommendations. Those were the priorities in terms of stopping using the issues, introducing the FAR process. There was then an internal review in 2021-22 to look at progress. And this is when lots of change started to take place. So there was revised timeframes. If you looked at the old policy and procedure, that existed around complaints process, it really didn't make sense, because what it essentially did is the more complex an issue, the more time the department had to actually investigate and assess an outcome in respect to that complaint. So the high complexity ones, the department were given 6 months to actually complete an investigation into that complaint. And what we know is that if issues have got to the point of being a high complexity, we're wanting action, we're wanting outcomes, we're wanting responses. And so that 6 month time frame was seemed to be really excessive. But not only that, what was occurring in practice is that it was actually going way over that 6 month period as well. And certainly experiences that we'd hear at QFKC, we're seeing ones that were 18 months to 2 years to get an outcome. And of course, when I said right at the beginning that, you know, we have carers accessing a complaint process, we want to encourage them to do that in a way and follow a process that the government supports, but at the same time, that process needs to be a fair and just process. And if that process itself is starting to be part of the issue, then we have a problem, because as an organisation, it was really difficult for us to encourage carers to access a complaint process that created more stress and trauma for them. So the next really important milestone is that the new policy and procedure that was developed in 2022 following that internal audit that looked at the need to change it, and really what the complaints unit did. And certainly we've spoken to the complaints manager and she's come and done some training with us, is that they looked at it from the view of the complainant. How would the complainant like to experience this process? What should it look like to them? And so the policy and the procedure that was developed and came into effect as of the 1st of July 2022 is really thinking about it from the perspective of the complainant, both in terms of timeframes, but also in terms of the need to focus on early resolution. But if we do get to a complaints process, then what is it that we can do to make sure that that complaints process represents a fair and just experience for the carer, for the birth parent, for anyone else that is accessing that process. Okay. So here is some of the overview of the key changes that you'll see has taken place. And I really want to, I guess, reiterate that if you are a carer or if you are a foster and kinship care service agency worker that accessed the complaint process a couple of years ago or 18 months ago or even a year ago and didn't have a great experience and are a bit hesitant to access that service again because of that experience, I want to say that we here at QFKC has seen a remarkable difference in the last, certainly since, you know, the introduction of the new policy and procedure, and we have seen change and we have seen outcomes achieved for carers. And I'm going to give you some stats towards the end about what that has meant in practice as well. So funded service complaints managed through the department's child complaints management system. So any complaints that funded services have and or that members of the public, if you have a foster and kinship care agency worker that you have, or an agency that you've not had a great experience with and you've gone through their complaints management process and are still not satisfied, then this is another avenue that you can go through to raise your concerns. But also that funded services are also able to raise a complaint through the complaints management system. So if you're a foster and kinship care agency worker and you are not being responded to or you have an issue that is not being addressed, then this is actually a process that you yourself can go through as well. So mandatory complaints training for all departmental staff. And like I said, that was a recommendation, remember, from that from those original recommendations, which has been put into place. Then the new complaints management policy and procedure, which we're going to have a look at through this training, that all matters that result in a complaint must have an outcome leader. And that is really important for a carer to understand what the outcome is and how that outcome has been reached. That the decision maker with appropriate authority is allocated for each complaint. So if you are making a complaint about a senior prac or a service centre manager, you would not have that service centre manager or a team leader being responsible for the decision making in respect to that complaint. It would be a person that has the proper authority to actually and independence to look at that. The first attempt at resolution. So this particular one talks about what are those steps, and we're going to go into those steps as we go on. But the first attempt at resolution is the first step, and then a complaint, and then an internal review, and then an external review. So those are the steps that we're going to explore today and how you go about that. And that the internal review options include both an internal merit review or an internal process review. And as we talk more about the steps when we go through this training, you'll understand the difference between those two requests. And increased information sharing and collaboration with the OPG. So that's in reflection of the recommendation around that memorandum of understanding and the importance of the OPG being able to raise concerns and issues that they have as a complaint through the complaints management unit and be responded to appropriately. Okay, so those QR codes that are up there will take you to the complaints management policy and procedure. They're really big. So the complaints policy is 9 pages long, and that's the one I have before me here. And the complaints procedure here is also 9 pages long. The best way I help people to understand the difference between policy and procedure is the policy is the what and the procedure is the how. So what is the complaints management policy trying to achieve? Like, what is it about? What are they trying to do? And then the procedure outlines how we're going to go about that. So it was updated and released on the 1st of July 2022, and it represents those learnings over the past 2 years since the implementation of the recommendations that came out of the Ombudsman report. The lens for policy and procedure, client-driven and focused with emphasis on, like I said, how the complainant would want to experience the process. And the lens required child safety to reconsider areas such as language, timeframes, streamlining and outcomes focus. So removing the word issues from procedures, making sure that timeframes are really concise and appropriate, and streamlining processes. So we're very clear about if this doesn't work, we go here. If this doesn't work, we go here. If this doesn't work, we go here. So a very clear step-by-step process. I'm a very process-orientated person and driven by process. So I have found the clarity in these new policies and procedures extremely helpful in the work that we undertake. Obviously, with QFKC, carers are contacting us because they're not necessarily having a great experience. We don't get calls from carers because they're wanting to share wonderful, positive experiences with us. So this is our bread and butter, and we need to be able to navigate the complaints process so that we don't become part of the issue as well, and that carers are not contacting us and for support and assistance, and we're actually not able to get an outcome or bring matters to a conclusion as well. Okay, so let's talk about the complaints management unit. So obviously it used to be called Central Complaints. It's not called Central Complaints anymore. It's called the Complaints Management Unit. And one of the biggest shifts, and this really excites me, is that previous to where we are sitting today, so a couple of years ago, the Complaints Management unit, or central complaints as it was called back then, actually sat under a corporate arm of the department. And so we can appreciate that when something sits under a corporate arm of the department, it's treated like a business. It's the lens that is applied under those circumstances are very different to what would be applied if it sits under a more appropriate section of the department. And that was recognised, and so now the Complaints Management Unit actually sits under the Chief Practitioner's Office, and that is brilliant, because what that means is that the shift now focuses to quality practice. What can we learn from this? So it's not about just, a business model, so to speak, or just, responding. It's actually looking at what those complaints that are coming through relate to, whether there is any systems issues identified, and that's where the department can grab hold of areas of quality practice that need to be improved. So absolutely fantastic. The complaints unit have access to a range of specialist services through the Chief Practitioner's Office. So under the Chief Practitioner's Office, it's a wide range of people that have all sorts of skill bases that lend themselves to being able to support a senior complaints officer in particular areas that the complaint may relate to. So we have specialists in the area of domestic and family violence, and alcohol and other drugs, and disability and mental health, and sexual and gender identity, Indigenous practice, practice advice and support, child sexual abuse practice, and in addition to the specialist service, the complaints unit can consult with the following teams that also sit under the Chief Practitioner's Office, including systems and practice review, child safety training, the NDIS interface team, delegated authority, and child safety practice manual team. And I can say from experience, I have supported a carer through an internal request, an internal merit request, and the department very much in the Chief Practitioner's Office relied on expertise within their team to help inform and the investigation and outcome in that one, and it was a really positive experience. Okay, so when we look at what is a complaint, we need to look at it from the definition that sits within child safety's policy. So the department defines a complaint in their policy. It has to not be out of jurisdiction. So the policy is really clear about what areas are out of jurisdiction, and this is where it's really important that we have access to this, because they're public documents. If you're wanting to make a complaint, if you're a foster and kinship care service that are wanting to support a carer to make a complaint, then these documents should be printed off, and you should be going through it to make sure that you're not going to actually undertake a whole complaint process where it could be out of jurisdiction. And that, so for example, I'm going to provide an example there so you know what I'm talking about. If you have a carer that has had children removed from their care, and there is a current matter before QCAT, and the carer is wanting to make a complaint about the removal of the child from their care, that would be out of scope, because that matter has been managed by the Queensland Civil and Administrative Tribunal through a review decision. If the carer in that instance was concerned about the harm report outcome and process that led to that removal, they could go through a complaint process to address the process of the harm report and the outcome of the harm report, but they would not be able to go to the complaints unit to complain about the actual removal of the child. So I hope that helps you understand the difference and what would be considered out of scope in that particular scenario. A complaint, an oral or written expression of dissatisfaction made on behalf of a complainant regarding a decision, the service provided, or the behaviour from an employee. It requires a response or a resolution. It would benefit from being managed in accordance with the complaints management policy without a first attempt at resolution being attempted. We're going to talk about that more as we go on in terms of If you are at that stage of a first attempt at resolution, you haven't actually raised a complaint. You are in the early stages of trying to resolve the matter. And then if you're not able to resolve at that first attempt at resolution stage, that's when you then raise the complaint. So what that is saying is, what this is saying, the policy is saying is, you either have already been through a first attempt at resolution and it hasn't worked, or in this instance, it may be that a first attempt at resolution is not appropriate, and we can talk about examples of where that might be the case as we go on. Okay, so these are the areas, these are the steps. This is what you need to think about in terms of a complaint process and steps to take when you're unhappy about, like I said, a decision, a behaviour, or what was the other one? Decision, behaviour, or let me just go back, service. Okay. So the first attempt at resolution. So the department encourages a local early resolution of your concerns. Contact your child safety officer or senior team leader. In the first instance, if you're having trouble getting hold of them, you can contact the complaints unit to raise a bar. At this point, I'm just going to read what the slide says, and then as we go on into the training, you're actually going to see more detail in respect to each of those. Then if that doesn't work, so first attempt at resolution doesn't work, you will then go on to a complaint. If you remain dissatisfied after your first attempt at resolution, or the service centre has not responded to you within the FAR timeframe, you can contact the complaints unit to escalate your concerns to a complaint. The complaints unit may devolve your complaint. In the internal review, if you remain dissatisfied with the findings of your complaint, so you've had your complaint, you've had your decision maker, you've had your outcome letter, and you are not satisfied with that, you can actually then make a request for an internal review, either merit or process, and we'll talk about the difference between those. Then that is the last step within the department that you can take. If you remain dissatisfied after an internal review request, whether that's been accepted, not accepted, or investigated, and the outcome is still one that you don't support or agree with, your next step is the external review, which is through the Queensland Ombudsman, or through the Industrial Relations Commission, or through the Queensland Human Rights Commission, or through the Information Commissioners Queensland. And we're going to talk about what types of complaints would sit with what in terms of those external reviews. Okay. So first we're going to talk about first attempt at resolution. And can I say, I'm going to throw in some stats here now. So I was talking to the manager of the unit the other day, the complaints unit, and 77% of first attempt at resolutions have been resolved at that level since the new procedure came in. So that's really positive. And remembering everything actually fits in with everything else. So when we think about mandatory training for child safety officers and departmental officers, when they hear the language, first attempt at resolution, they know that this is a carer or a birth parent or whoever following a policy, following a procedure, and that if they don't get a response at this level that they are happy with, then the next level will be a complaint. So there needs to be that engagement from the department to resolve it at that local level in line with their policy and procedure. So it's prior to a complaints process. It's resolved at the point of service, so at that local service centre level. It's early resolution. It forms part of casework, and it can have flexible responses and outcomes. Now, here at QFKC, we are probably daily now, I would say, writing emails to service centre managers or senior team leaders or team leaders saying, we are writing this email as a first attempt at resolution. So we use that language in the emails that we are sending, and then we list what the issues are, and then we list what that relates to. So we may raise the statement of commitment, we may raise concerns around human rights, we may raise concerns around statement of standards, charter of rights, those kinds of things. So we're really clear about, well, what does our concerns relate to in terms of the service, the behaviour, or a decision that the department has made. So using that language is really important. We had one whereby a staff member did that, use the statement of commitment in her rationale as to, the outcome that we were seeking, and literally within 2 days we had a positive outcome for that carer. And that's just one example of many that we've had where that has been a really successful way of being able to address issues. I've also spoken to Foster and Kinship Care services where they've contacted me feeling really frustrated probably with the system where they're not getting a response from the service centre. And, I say, have you tried a first attempt at resolution? And they may not be familiar with that language. So they try it and then get back to me and say, oh my goodness, that worked, we've got a meeting. So, can't stress enough the importance of using that language when you're doing an email where you've tried to resolve an issue, you're not getting that resolution. It's at the point where you think, right, I need to really do something about this. And then we start to engage in that first attempt at resolution process. Okay, so I'm talking to you about what we do here, and I thought what would be really good throughout this training is to put that practice element to it so that you understand where we're coming from and what we mean. So we're going to do a bit of an activity. I'm going to read you out an email, and all of the links to these activities and stuff will be up on our website. So Molly has been asking her CSO for additional care allowance. That should, otherwise known as high support needs allowance. That may change the language we've changed here because we're expecting a change in language into the future. So she's asking additional care allowance level 1 to be considered for 2 children placed in her care 3 months ago. Molly and her Foster and Kinship Care agency have provided relevant information to the CSO on 3 occasions, which supports the application for additional care allowance. To date, Molly has had no response, and the CSO is now not responding to the emails where this is the related topic. What can Molly do? Okay, so what can Molly do? Let's go to our next slide. These are all sorts of internal and external avenues that could be available to Molly, and carers can feel really overwhelmed about what to do. So what could Molly do? She could contact the senior team leader. She could go directly to the Ombudsman. She could contact the DG. She could contact the service centre manager. That should say go to QCAT. We need to fix that spelling mistake. Could she go to QCAT? Could she go to the Central Complaints Unit? Could she call Regional Complaints Office? Could she contact the Crime and Corruption Commission or the Minister's Office? Or could she contact the OPG? Now, in those instances, the things that she can't do is she can't go to QCAT because it's not a reviewable decision. She can't call the CCC because the crime hasn't been committed. She could do all the other things, but in doing that, what is likely to occur, if you are a carer that has an issue and you go directly to the Ombudsman, the first thing the Ombudsman is going to do is they are going to ask you whether you have attempted to address the matter through the complaints process available to you. And if you haven't, then it will be referred back through that complaints process. And that is typically the same for the ministers in the DG's office, is that they obviously have a policy and procedure that supports early resolution. So they want to see evidence that before you've actually gone down the steps of contacting someone at such a high level, that you've actually followed a policy and procedure and attempting to address it at that local level. So let's see what Molly does in this scenario. Molly calls the Regional Complaints Office. Molly contacts the Regional Complaints Office to raise a first attempt at resolution. The Regional Senior Advisor refers Molly's first attempt at resolution to the Child Safety Service Centre for a local resolution. They've got 5 days to respond. So the timeframes for a first attempt at resolution is 5 days. The CSO and the senior team leader met with Molly to discuss the additional care allowance. A timeframe was agreed upon to put forward the application to the service centre manager for a decision. But before that, hang on, we've clicked over. So I haven't done the letter that we've done first. Can we just go back for a sec and back again? Okay, so what I need to do first is that in the first instance, what Molly needed to have done is attempted that first attempt at resolution. So I'm sorry, I just skipped ahead there. So go back, Danny, go back. I'm going to read you the letter that Molly sent to the senior team leader and or manager in her first attempt at resolution. So this is the first point. I'm emailing regarding Johnny and Maria Little, who were placed in my care 3 months ago on 1st of August. Soon after they came to me, I began to notice both children have some care needs that required additional support. These care needs relate to the behaviour and development of both Johnny and Maria. However, neither child at this stage meets the criteria of the NDIS. Both children have low muscle tone impacting on their ability to chew solid foods, and they both require a protein supplement drink 3 times per day as recommended by the GP while assessment occurs and then treatment, which will hopefully bring some improvements in this area. This low muscle tone also impacts toileting, requiring age-appropriate incontinence aids for urinary and fecal incontinence. My agency and myself discussed this with the children's CSO, Jenny, as part of a home visit in late August. Jenny advised of the information needing to be provided to make an application for the additional care allowance as the recommended protein drink and appropriate incontinence aids at a considerable cost to the family budget over and above what the fostering allowance reimburses for. I worked with my agency worker, Megan, to calculate the costs associated and seek a GP report that speaks to what is needed and the benefits of this for the children. This information has been provided to Jenny on 3 occasions to date. However, I have not received any acknowledgement of the application, and follow-up emails from myself and Megan are not being responded to. As the carer for the children, I'm committed to advocating on behalf of Johnny and Maria to ensure they receive the support, resources and services required to ensure their best interests are met and allow them to ultimately meet their full potential. Now, this is what we do. The statement commitment speaks to the support that will be provided to me as a foster carer for Johnny and Maria. It states Foster and Kinship Carers will receive and should expect support that will help them provide a safe and caring environment in which the needs of children and young people are met. And then as members of a child or young person's safety and support network and care team, all participants will be treated fairly and equally with courtesy, respect and personal dignity and will be recognised for their unique knowledge and contribution to safety and case planning, including child safety committing to the following: provide emotional, therapeutic, practical and educational support for both the child or the young person placed in their care and the carers themselves. I also draw your attention to the agreement that the statement of commitment highlights as it acknowledges as acknowledgement of the critical role carers play in the lives of children and young people in out-of-home care, in addition to my role as a volunteer member of the care team. This email expresses my concern regarding the service I'm currently receiving as the carer for the children, and I'm requesting that you as the senior team leader for Johnny and Maria review the application for the additional care allowance and the lack of response received to me in relation to the care needs of Johnny and Maria and provide a timely response. Given my attempts to resolve this matter with the CSO have been left unanswered, I'm seeking to address this matter through a first attempt at resolution. I'm available to meet in person or via phone or Teams and look forward to bringing this matter to a resolution that meets the needs of your carer. Okay, so what we have is we have Molly that has tried on 3 occasions to get responses from her CSO. She has been unsuccessful in that. So her first protocol is a first attempt at resolution, and what she's done is an email. She's been very clear about what her concerns are. She's been very clear about what service she believes she's not receiving. She's taken the emotion out and she's related her concerns to the statement of commitment and pulled out very clear areas where she feels that the statement of commitment is not being met. And then at the end, she's been very clear about the outcome that she's seeking. And that's what's really important in the first attempt at resolution. Not just raising what the issues are and what they relate to, but what is the outcome that you're seeking and how do you expect that that will be met. So in her instance, she's wanting it to be reviewed by the senior team leader and a decision to be made, and she's happy to come together for a meeting. Okay, so that's her first attempt. Now, what happens is that she's not responded to, okay? Can you go back, Danny, because this is where yeah. And so when her first attempt at resolution is not responded to, Molly has those areas. Can you just go back one more? Has those areas. What can she do? So first attempt at resolution is not responded to. What is it that Molly can now do? And those were the things that I spoke about before. And again, she can't go to QCAT. She can't go to the CCC. And those other areas in terms of going high up would likely just move her right back down again. So this is where Molly decides to go to the Regional Complaints Office. Apologies for skipping ahead before. So she goes to the Complaints Unit, to the Regional Complaints Unit. Now, recognising that we have a Complaints Unit that sits at head office, but we also have regional complaints officers that sit in each region as well. And so in this instance, Molly has decided to go to one of those regional complaints. So can you move forward? And then move forward again. So the complaint. Now this occurs after a first attempt at resolution. So in her first attempt at resolution, it was not resolved. The initial step in the complaints process has 3 categories. So the senior complaints advisor will determine which category to engage as the most effective method to achieve resolution. So essentially, when you raise a complaint, there are 3 areas in which the department can respond or manage that complaint. One is a direct response, so that involves a meeting or facilitate a conversation with the service centre manager as a delegated decision maker. 2, an investigation can occur, involves a thorough investigation of the allegations that are made. And 3, a practice review can take place. So that involves an evaluation of practice, looking at policy and procedure and identifying any gaps. So what happens when you raise a complaint? The concerns are managed by an appropriate officer through one of those 3 response pathways. The complainant is provided a findings letter with the outcome of the complaint, and the complainant is entitled to provide feedback in relation to the findings. So in that initial letter that is provided, carers or the complainant has 28 days in which to respond to the concern, in respect to the outcome if they don't agree with it, and provide that feedback to complaints. And sometimes they will, sometimes they won't because they accept the outcome, or sometimes they won't because they actually want to progress it to the next stage, which could be the internal review. The complainant is provided information on where to escalate the concern. So in that outcome letter, the complainant will be told that if you don't agree with this outcome, 1, you can provide feedback, or 2, you have the ability to raise an internal review request or merit review or process review. Okay, so Molly heard back from her CSO yesterday to advise that the service centre manager has not approved the application for additional care allowance. So despite her first attempt at resolution, that has not been approved. Molly has asked for a rationale. The CSO advised that the only information she has is that it has not been approved. So through her first attempt at resolution, what she's done is she has raised that, the meeting has occurred, the senior team leader has taken that application to the service centre manager, and the service centre manager has said that she's not going to approve it, and no rationale has been provided. So she raises her complaint. So again, where can she go to raise that complaint? And in this instance, what does Molly do? And remembering she can't go to QCAT again, she can't go to the CCC. The OPG are likely to refer her back to the service centre because their role is obviously to look at the specifics of what is in the best interest of the child. And certainly you could argue with the OPG that by not having the additional care allowance met, the child is missing out on needs being met. And so you could get certainly the OPG on board and they could actually raise a complaint as well. But they are not a decision maker here. They can't make the department change their mind. So Molly calls the complaints unit. So she's been through her first attempt at resolution. through contacting the regional office and going through that first attempt at resolution. Now the complaints unit, she contacts the complaints unit because she's not satisfied with the outcome. The outcome has been that she's still not going to get the additional care allowance and that there's been no rationale. So yes, the first attempt at resolution has resulted in a decision being made about the additional care allowance, but it's not a decision that she agrees with, and she doesn't understand how that decision has been made. So the complaints unit accepts Molly's complaint and refers to the regional complaints office for an investigation by the senior complaints advisor. The delegated decision maker for the complaint has been identified as the regional director for the area, as this is an appropriate person with delegated authority, remembering that the RD sits above the manager. In this particular instance, the manager has been the decision maker, and in line with recommendations made by the Ombudsman, the decision maker for a complaint needs to be in an appropriate authority in order to make a decision. So it can't be the manager of that service centre because that decision's already been made. So what often happens in this process is that the carer will put forward what their concerns are, and the complaints unit are really good at actually breaking those down to what they identify as allegations. And so they're really clear about what is it that we are investigating. And those allegations are shared with the carer prior to the investigation commencing, so that there is an agreement in relation to what it is we're actually doing here, and we don't get to the end of a complaint with an outcome and the carer saying, well, no, you actually haven't investigated the areas that I thought you were going to. So that has to be really clear. So in this instance, the allegations are that the service centre manager has not provided rationale as to why the application for ACA has not been approved, that Molly has demonstrated out-of-pocket expenses relating to her care of the child that has not been properly recognised or reimbursed, and that the child will miss out on recommended therapeutic interventions without the ACA, and therefore their standards of care will not be met. So those are the three allegations that the complaints unit in this particular instance have come up with, shared with Molly, and Molly has said, yes, I agree that those are the ones that need to be investigated. So remember that there's three ways in which a complaint can be managed. One is through a meeting with the service centre manager or with the office. 2 is through an investigation, and 3 is through a practice review. In this instance, the complaints unit has decided that it needs to be managed through an investigation. Okay, so in Molly's instance, let's see what her outcome was. Molly receives a findings letter with the outcome of her complaint from the regional director, because they have been the person that has been identified as the decision maker. It finds that she did not receive a rationale for a non-approval, and a recommendation is made that the manager provides a rationale to Molly. Now, it used to be only a few months ago that outcomes of investigations, the language that we used within the complaints unit was either substantiated or unsubstantiated, and then there would be recommendations. That language has now gone. That language is not being used anymore. The language that is being used is either further action is required, and there is other outcomes as well, which we'll get on to as we go on through the process. So it was just about taking some of that kind of negativity away from the process and making it very solution and outcomes focused. So here, their finding was that no, there was actually no rationale provided, and so then being solution focused in this space, the request to the manager in this instance is you need to provide a rationale as to why you've not approved this. The investigation supported the manager's decision not to reimburse Molly and indicated that no further action would be taken. Molly has an opportunity to provide a response to these findings before the complaint is finalised. But Molly decides in this instance that she's actually not going to respond. She would like the complaint finalised so that she can proceed with a request for an internal review of the decision not to reimburse. Molly feels this would be better achieved through this process because she wants it taken out of the region. She would like it to sit with the complaints unit for them to take a fresh look. So Molly now needs to put together in writing a request for an internal review. So let's have a look at what Molly does. What is an internal process review, merit review? So there's a difference between a process review and a merit review. And often what we're hearing from the complaints unit is that if an internal review is accepted, then often it will involve both. So the process review is reviews the process of a finalised complaint. For example, you were not given the opportunity to provide feedback. It's backwards facing and it's focused on the complaint process. So it's more about the process of the complaint was not fair and just, not necessarily the outcome, but the process of it. The merit review investigates the original concerns raised. It's forward-facing, it's solution-focused, it's collaborative, and it may include a review of the previous complaint process. So the merit review is more about the outcome, whereas the process review is more about the process that led to the outcome. So as you can see, it's often, if you have an outcome that you don't consider as fair and just, then often the process to reach that outcome was not fair and just either, which will explain why both of those are done together. Okay, so here are the key considerations for an internal review as outlined in departmental procedure. It's always managed through the complaints unit. So we've talked about Molly's experience of it being the complaint being allocated to the region, the regional senior complaints officer, and that the regional director was the decision maker in that particular area. For internal reviews, it actually sits within the complaints unit. So it's not investigated or assessed by someone outside of the complaints unit. Requests for internal review should detail what specific aspects of the complainant findings or process the complainant disagrees with. So you can't just put an internal request and saying, I don't like the outcome, I want to review. You need to identify what it is about the process or about the outcome that you don't agree with. What went wrong? So that's really important. An internal review should take no more than 45 calendar days from the day of your concerns being raised to receiving a findings letter. Complainants will be advised in writing if the internal review response requires additional time, and a new revised timeframe will be provided. Every internal review will be assigned an investigator and a decision maker. A single employee can perform both roles if they might meet criteria, which is set out in the procedure. Terms of reference are identified. So rather than allegations, which what we refer to in the complaints process, once we get to the process of an internal review request, we're actually looking at terms of reference. And like with the complaint process, where the allegations are shared with the carer or the complainant beforehand to ensure that their understanding of what is being looked into is accurate, that is the same for an internal review request. So the terms of reference that the investigator comes up with will be shared with the carer to ensure that their understanding of what the investigation is going to look at is accurate. And in fact, what carers can do when they request their internal review is they can actually put very clearly in that internal review what they would like to see in those terms of reference. And again, when an outcome is reached in respect to an internal review, a written response, which may include a written report, is required and a right of reply to the findings and decisions, and outcome advice must be afforded prior to the final determination. So a letter will be sent to the complainant saying, these are what our preliminary findings are. Do you have any feedback? They're given a time frame for feedback, and then the matter is finalised after that. Okay, so then again, if we go back to Molly, so she's tried a first attempt at resolution. She contacted the regional complaints, they referred it for a first attempt at resolution. She's written the letter to the complaints unit, that's become a first attempt at resolution. There's been a meeting that's taken place, there's been a decision that's been made. Molly hasn't been happy with that decision. So she has raised a complaint. From that complaint, three allegations were formed. One of those allegations required further action in terms of a rationale from the service centre manager being provided to Molly. The two other were not required no further action. Molly is not happy with that. So now Molly is going to put together an internal review request. So what will some of Molly's main points be in the request for the internal review? She's going to ask for a merit because she's not happy with the outcome. It's not just the process, she's not actually happy with the outcome. So she will refer again to the statement of commitment, and she will refer to every point within the statement of commitment that she feels is not being met through the decisions that have been made. She will refer to the statement of standards and the Charter of Rights. So she will look at the therapeutic needs of the child. So if we look at, I've grabbed all these documents here, because what I do, and I wrote a first attempt at resolution the other day, and what I had before me was the documents that I would need that related to the area that I was looking at. So here I've got the statement of standards, I've got the human rights, and I've got the Charter of Rights. So when we consider that if the GP has said that the carer requires this, that the child requires this intervention and it comes at a cost, and the fostering allowance doesn't cover that cost, then by saying no to the additional care allowance, we're either saying one of two things. We're saying that the carer has to pay for it out of her own pocket because it's not included in the fostering allowance, or we're saying that the child goes without. And so then when we look into the statement of commitment clearly states that carers have the right to be financially reimbursed. So that's that area taken care of, like the carer shouldn't be out of pocket. And then if we look at the therapeutic needs of the child, then we use the statement of standards and the Charter of Rights to support our submission in that respect, that by not, if the carer was not to pay for this and the child was to go without, then these would be the needs of the children, that the child that would not be met. So you would talk about the child will receive dental, medical and therapeutic services necessary to meet his or her needs. You would go to the human rights, and you would go right to the right to health services, and you would just use the documents available to you, because what is really important in these, in either a complaint or an internal review request, is that you take the emotion out and you stick to the facts. And the best way of doing that is to use the documents available to you to evidence your case. So we've used the statement of commitment, we've used the statement of standards and Charter of Rights, we use the fostering allowance policy. So we quote what the fostering allowance policy is and is not for. So we've provided evidence there that the GP has said that the child needs this. The fostering allowance says that it's not in there, that it's not included. So then it needs to be met through the department. And we also need to highlight that Molly, so this is the process thing, so all of those other ones is the merit, but this is where we would quite possibly, where the complaints unit would actually accept this as an internal merit review, but a process review as well, because Molly was not contacted through the complaint process, and supporting documents do not appear to have been considered, for example, the paediatrician report. So that's a process issue. Remember what I said before, if the process is fair and just, then the outcome should be fair and just. So if we have an outcome here that we don't agree with, so what was it about the process also that may have led to that outcome that was not fair and just? And in this instance, actually, well, Molly wasn't contacted, none of the supporting evidence was provided, and so we don't feel that the process to reach that outcome was a fair and just process. I know that there's been some questions, and I'll get to those at the end. I'm just going to finish the couple of slides that we've got left, and then we'll have some time for questions. So when I spoke to you before about the language that had changed, we're not using substantiated or unsubstantiated anymore. These are some of the possible complaint outcomes. There can be an apology, there can be an explanation, there can be information provided, there can be a decision determination identified for review. It can be that the policy or procedure is identified for review. So there may be an area of practice that has been highlighted that actually the policy and procedure currently in place is not sufficient, and we need something else to properly reflect children and young people's needs and the needs of carer families. It could be that service is identified for review, staff practice is identified for review, or an outcome of no further action. So then for an external review, so Molly was lucky, she had a great outcome in the end because she put all those supporting documents forward, and I'm pleased to say this is a completely made up story, but in Molly's case, she got her additional care allowance. Let's say Molly didn't get her additional care allowance, what could she do? She could go to the Queensland Ombudsman, who have an oversight function for investigating and administrative decisions of the department through an external review process. So in Molly's situation, that would be the most appropriate for her to go through. She could also go through the Human Rights Commission if the matter directly related to a breach of the human rights. So you have to have some really clear evidence there around a breach of a human right. So an example there could be if you've followed a complaints process for an Aboriginal and Torres Strait Islander child to have more contact with family, that has involves a significant financial cost to the department by, flights and accommodation, the child, going back to country. And let's say the department through the complaints process said, no, that's not something we're going to support. And I doubt that it will get to the stage, but worst case scenario, you could then raise an issue with human rights, because the Human Rights Act talks about the right for children and young people to be connected to their culture. You have the right to enjoy your culture, practice your religion, use your language. And with Aboriginal and Torres Strait Islander people, Aboriginal people and Torres Strait Islander have the right to enjoy their culture, including maintaining their cultural identity, traditional knowledge, spiritual practices, beliefs and teaching, languages, kinship ties, relationships with land, waters, sea and the environment. So in that instance, if a young child or young person was being prevented from having reasonable time in the community, then that would be an example of an issue that you could raise with human rights. And then Molly could go to the Office of the Information Commissioner, but this is if her complaint related to an information privacy breach. So there's really clear external avenues of complaint dependent on what the issue is. Again, I just want to reiterate the importance of those supporting documents when you're putting forward your first attempt at resolution request, your complaint request and your internal review request, because it is the supporting documents that will help you put your case forward in a really concise way. And it really does help to take the emotion out and keep it child focused and care-centred and family-centred as well, because all of those supporting documents, such as the Statement of Commitment, such as the Standards of Care, such as the Charter of Rights, such as the Human Rights Act, all are child-centred documents. Okay, so again, the complaint should always look to resources. So refer to the Statement of Standards. Do any of your concerns relate to the commitments made by Child Safety under the Statement of Commitment not being met? Human Rights Act, like I just said, Child Safety Practice Manual, which is available to everyone. We just had one a couple of days ago where a carer that has long-term guardianship of a child with not long-term, but wants long-term guardianship of a child, has not had a case plan forever. We sent an email, carer needs a case plan. It came back, no, they're not entitled to one. So all we did was cut and paste the section within the practice manual that says the carer is entitled to one and flipped it back. So that provides evidence, and hopefully it's resolved at that level because we've provided the evidence to support it. So we're not going into this emotional debate about what carers are entitled to or not, because it's not our decision around as a peak body as to what carers are entitled to. What we are advocating for is what the department's practice manual states they're entitled to. Recorded all the way. So all first attempts at resolution matters, complaints and internal reviews must be entered into the department's electronic complaint management system. And that's called Resolve, to ensure consistent monitoring and reporting and to enable effective review and ongoing systems, practice and improvement. So remembering that sits under the quality, under the Chief Practitioner's Office now. And so there's real ability for the department to see where they need to be focusing the energy in terms of practice improvement. This means that patterns will be identified, and I love my sayings, the whole is greater than the sum of its parts. Okay, so just some final tips for navigating the complaints process. I need to also let you know that since this complaints process, since the 1st of July last year, the amount of matters going to the Queensland Ombudsman has halved. So what that demonstrates is that we have a complaints process within the department that has the ability to work and is working, and we actually really need to be using it. Because we want to get early resolution. We don't want to be in conflict with one another, because when we're in conflict with one another, what that does is it takes the focus off the children and young people. And so one of the things when the complaints unit manager came and did some training with Brian and I last year, is that prior to all these changes, what they identified is that by the time foster or kinship carers were raising matters, so in the old days when they had the low, medium and high complexity ratings, more foster and kinship carers were in that category of high complexity than any other group of people. And that is because carers would leave it and leave it and leave it, and we didn't have those processes that we've talked about that were clearly articulated today to try and get that early resolution. So by the time it got to the complaints unit, the complexity was so high. And what we know is that the ones that are going to be affected mostly by conflict that is rated as high complexity within the department's complaint system is the children and young people. So really, really important that we know how to go about resolving issues. So what do? We keep a copy of the policy and procedure handy. You've got the QR codes for those. All you need to do is to, if the QR code's not working, just Google child safety complaints process and Queensland, and it will come up, and the procedure and policy are on the front page. They're very easily accessible. Always use the correct language associated with the process you are instigating. If you are instigating the first attempt at resolution, you need to say, I am instigating the first attempt at resolution, because that then starts to trigger a particular process that the department will undertake. If you are raising a complaint, you need to use that word. If you are instigating an internal review, merit or process review, you need to use that language. Ensure you access your Foster and Kinship Care service and your QFKC with support and guidance through this process if you need that. Try to take the emotion out and draw on those policies, those procedures, legislation and documents such as the statement of commitment to form your position, and keep a record of your communication relating to the processes you're undergoing to include dates, times and the person you've spoken to if verbal. So those are our contact details. We obviously have our head office here in Brisbane and our Townsville office. I do, before I need to go on, need to do a bit of a spiel. We are looking for QFKC support team members. We are looking to recruit foster and kinship carers into that role. If you are interested in being a volunteer for our organisation, supporting other carers through this process, many processes, but one of the processes you may be supporting them through is a complaints process. We offer training, we offer ongoing professional development, attendance at our conferences. So if you're interested in being a QFKC support team member and you are a current foster or kinship carer, please contact the Brisbane office and ask to speak to Maraka. And the other thing I just need to put out there as well is to remind everyone that we have our state conference coming up in April, from the 28th of April to the 30th of April in Cairns. We're going regional. We have got some incredible keynote speakers that will be there, and workshops galore. And we're really keen to have as many carers and sector staff there as possible. So I just needed to do those two plugs before I look at the questions and see if we can answer any of those. Just bringing up those now. Okay, does the service centre manager actually contact the carer before the decision? So if you're talking about the first attempt at resolution, if the first attempt at resolution, if the letter has been to the manager, then it should be the manager that is coming back for that decision. Not necessarily though. I mean, in Molly's instance, the manager provided that decision to the senior team leader or to the CSO who provided that decision back. So the first attempt at resolution, remember, is not at that complaint level. It's trying to prevent a complaint from taking place. And so there's no requirement for an outcome leader or for a particular person to provide that outcome. But certainly with a complaints process, once it reaches that level, whoever is the delegated decision maker must provide a preliminary findings letter to the complainant saying this is what our decision is, this is what we've come to. Do you have any feedback before we make our final decision? So hopefully that answers that question, Heidi. Are there template letters available? That's a really good question, and there's not, but that's not to say that we can't put some together. So I think that's parts of that will be tricky because it will depend on what the issue is that you are raising. Yeah, there could be some trickiness about trying to do that. But I guess moving forward, your best bet is to really contact QFKC, your Foster and Kinship Care worker, and we can support you. This letter that I read out to you today for the first attempt at resolution will be uploaded onto our website along with the training. So you will have access to that, and that might help you to formulate that. In terms of the complaint, you don't necessarily have to have a letter in respect to that. So you don't have to write a letter to the department. You can ring them, you can email them, and like I said, it's the senior advisor from the complaints unit that will actually formulate through the concerns that you've raised what the points of investigation will be. Okay, so if a carer has considered a complaint regarding a decision made by the department but does not initiate a complaint because of the struggle, the stress, the mentality and fear that's attached to doing this, can you just go, carer writes a letter of advocacy outlining why the department's decision is not the best outcome for the child. Can the carer's letter be regarded and treated as a complaint even if it's not? I think you just have to be really clear on what you're hoping to achieve in any letter. So whether that's the first attempt at resolution or a complaint process, you need to be clear about what you are trying to achieve. So if you're wanting to put concerns forward to the department, but you're not wanting it to be treated as a complaint, you just need to say that at the beginning. I am not writing this to initiate a formal complaint process. I am initiating this to raise concerns in relation to whatever areas. I guess what I would say to you there, though, is the way change is going to occur is so remembering if it is recorded as a complaint, then it's put into that resolve, into the department's computer system, which says resolve, which is named resolve, sorry. And that sits under the Chief Practitioner's Office now. So this is where we're going to identify where there may be systems, issues and concerns that can be addressed at that higher level. So my worry is that lots of carers are raising issues with service centres, and I use that word issues because remember that's what was happening before. They were just being treated as issues. They weren't being recorded. There was no formal kind of process to them, and the resulting outcome was that there was no outcome. So I would encourage carers, I would hope that through your first attempt at resolution, you will be actually resolving some of those worries and concerns that you have. If the letter was sent to further understand and query. Sure, that's meant. So you're. Oh, okay. I do think I understand what you're trying to say there. So if you're just wanting to put a question forward, you're not wanting it raised as a complaint. Yeah, well, you can do that. You can definitely say, I'm not raising this as a complaint. I'll call that a first attempt at resolution, though. That, these are my worries. I'm addressing this as a first attempt at resolution. I would like to meet and talk about, these particular areas. of concern that I have. Or if you don't want to follow any of those processes, you can absolutely just raise any form of concern that you have with the service centre. It doesn't have to be through a complaints process. So for 11:53, does anyone have any final questions? Like I said, this training will be uploaded, all of the documents. So you've got the QR code to the procedure and the policy. You've got the Ombudsman report if you want to have a look at that. We will upload the example of the first attempt at resolution email or letter. If there's anything else that you think you would benefit from, by all means, let us know. And if there is no other questions, we will finish. Thanks, Michelle. That must mean I answered all your questions. So we've got one here. So just to be clear, if we ask for a first attempt at resolution, rather than just stating an issue, it will be recorded and help the service centre to look at their procedures. So it will be recorded in the resolve, absolutely, and it tracks it. So that's, like I said, where that resolve system, the department have access to the whole of the resolve computer system, and they would be able to track where there is a area of consistent concern within particular service centres, perhaps. So most try to avoid complaint. How can we as carers be encouraged? Oops, can you just go up, Danny? Most try to avoid complaints. How can we as carers be encouraged to start the complaints process when there is no support previous to complaints? I think that's where you really need to access your Foster and Kinship Care agency. Look, the whole idea, and like I said, 77% of matters are being resolved at that first attempt at resolution. So it is a system that is working, and that is a system that brings everyone together and tries to get that early resolution. If that doesn't result in an outcome, then Foster and Kinship Care service agencies should be supporting the carer to make a decision as to whether they would like to then progress with a complaint. And like I said, being really clear about what it is we're trying to achieve through this complaint, what outcomes am I trying to seek. If you're not getting the support that you feel that you need from your agency to do that, then by all means contact us here at QFKC, and we can support you through that process. So I just had a question about the resources. The resources will be all uploaded onto our website. So when you go onto our website, click onto the training tab, all of our webinars that we have recorded will be on there, including this one, and all the resources linked to this particular training will be on that as well. Now, like I said, this was the very first time we did this training, and I kind of got a little bit mixed up at the beginning with the first attempt at resolution and going straight to a complaint, but we got there in the end. If I have confused anyone, if you're leaving this training and not feeling like you have a really clear understanding of how you can manage a complaints process, please by all means give us a call and we will talk you through that. And we hope that this process and this webinar and the information that you have received today will help bring about positive outcomes for your carer families and for the children that you provide care for. Thanks, everyone.